So what is MA21? MA21 was formed in 2007. This is the Massachusetts Alliance for 21st Century Disability Policy. MA21 is a partnership of self-advocates, family members, stakeholders, and the Commonwealth's leading disability advocacy organizations, including the ARC of Massachusetts, Massachusetts Advocates Standing Strong, Mass Families, Massachusetts Down Syndrome Congress, Advocates for Autism of Massachusetts, the Disability Law Center, and Massachusetts Sibling Support Network. MA21 is committed to protecting the right of people with disabilities to self-determination. MA21's effective advocacy on Beacon Hill, in collaboration with other stakeholders, helped pass the Real Lives Law. MA21 continues to empower individuals and to influence leadership through education, advocacy, and the united strength of our members. To learn more about the Real Lives Law and the self-determination, self-direction service model, we encourage you to visit the MA21 website. The link we will go ahead and put right into chat, and also utilize the MA21 library. There's so much information in the library that will help you to understand the law, its history, and its current implementation. At this time, I want to introduce our speaker, Attorney Ann Grenier of Fletcher, Tilton, PC. Thank you, Attorney Grenier, for your willingness to present on a very important topic, the DDS appeals process. We truly appreciate your time and willingness to be with us and provide us with this important information that will just help us in our advocacy.
So thank you for inviting me to speak. I'm Ann Grenier, and I'm from Fletcher, Tilton. In our department here, I'm in the Trust and Estates Department, which is mostly for special needs for young adults, and also for adults up to whatever age who are disabled. And our group basically, in my personal practice, I do guardianships, conservatorships, and I also do administrative hearings with DDS to advocate for our clients' family members. So today I'm going to be speaking about DDS, appealing DDS decisions. So first of all, what are the issues that you can appeal? And those are set forth in 115 CMR 6.3 through 6.34. And I would encourage everyone to download those and read them over, because they really set forth. The more you educate yourself and appeal, the better off you are in terms of arguing the situation. So one appealable issue is eligibility, and that can be domicile, which is basically, are you domiciled in Massachusetts? And that includes, is the person's intent to remain in Massachusetts, and have they really made it their home? So we have many young adults who might have gone to a residential school, paid for by the public school. And of course, their domicile is where their parents resided, which may be out of state. I've worked with clients to establish domicile, where they've been able to have a lease for an apartment, be able to show that they are members of the community, and so forth. Another part of eligibility is establishing if you have an intellectual disability. That means that you have to establish there's a significant limitation in intellectual functioning, and that usually is by an IQ score of 70 or less. But oftentimes, we're often arguing about the person's disabilities, whether it's actually intellectual, are there mental health issues, or there's some other learning disabilities that are drawing their score down. Another issue is also, is it a related condition? So does the person have autism or some other related condition that would then make them eligible for community supports? Another appealable situation is priority. So we know as once you become eligible for DDS, the next step in the process is establishing priority. And that's usually done by a series of assessments, which is the MASCAP, which is broken down into the ICAP and the caregiver assessment. So in some of those situations, we're looking at what assessments were done, were they done accurately, and we appeal that priority status. Priority 1 means that you have an immediate need, almost an emergency need for residential placement. A priority 2 will say that yes, their need is there, however, it's not imminent, and therefore it can wait. So oftentimes that's something that we appeal to really show why we think it's an emergency or an imminent need. Once you are receiving services, an independent service plan is developed, and there are numerous assessments that take place in order to develop it. Sometimes when you have an ISP and the assessments are insufficient and we feel that we need additional services to be able to get those services, that's an appealable event, and there's discussion regarding what kind of assessments, and then perhaps the family gets additional assessments to supplement what DDS has done. Also for the ISP are the goals. Sometimes I've had clients come in and they say, well, we've gone through the ISP and it seems like just a formality, but the goals are very, very important because that's what makes the services meaningful. And so we spend a lot of time with our clients in talking about the goals and if they're appropriate and if that's the direction what we want to be going in. Also, we're looking at whether supports are restrictive. So whether, there are times where, I've had discussions like for clients who, maybe they're in a van and they have like a buckle buddy and they feel that's too restrictive. Or, there's other things that are part of the plan that we feel are not appropriate. And that's a measure where we can appeal it through the ISP. Use of behavior modification, medications, and restraints. So this one is, of course, you can appeal DDS. I've also gone through the courts through guardianship because you would need expanded authority if it was an antipsychotropic medication or it was an excessive behavior modification plan. So I've tackled both of them, maybe even simultaneously. If we had concerns about how the person was being restrained either chemically or physically, or if we disagreed with the behavior modification plan. And the failure to implement the ISP is a big one because there are times where there aren't those group programs out there, or we're waiting for a particular program, or someone has had some behavior problems and they've really not been able to get a day program. So oftentimes with this one, I've often worked with advocates or support brokers. So we work with DDS to try to identify proper, programs that might be possible, and to see if we can get referrals out and so forth. Another one, whether the rules for the development modification of the ISP are followed. Sometimes the ISP is late. We don't have the meeting, the corrections that the clients requested were not made, or it just really doesn't represent the person. So that's something that's also appealable. And the last one is whether decision-making supports are appropriate. And so sometimes, that family members really would like different kinds of support, different things that, are out there that can make their family lives, much better. I've had clients be like, well, they want some pet therapy or they want music therapy and so forth. And so that's other areas where we've appealed, and we've worked with DDS even prior to even filing the appeal. And many of these things can be solved before we even get to the appeal process by really trying to work together and partnering with the DDS. So the next are the grounds appeal for self-directed services. So self-directed services, this is another program that DDS offers in which you can get a budget and the family member or someone else can direct the services. Sometimes the family member may partner with an agency who's going to help you, find caregivers, help you with the budget and implement the services, or the family member does it themselves. So based on this, what I really recommend if you go the self-directed service route is to really develop a budget. And the budget is based on doing the schedule. So I've used we have a lot of advocates and support brokers that Fletcher Tilton partners with. And what we do is we really work on a budget from morning right through the evening to really account for every part of the day. So, because it's all based on need. So if you come in and say, I just think I need this, it's not going to be an adequate discussion. What we really want to know is, all right, when you get up in the morning, how many hours are going to need to get ready to take the van? Is there somebody that needs to be on the van with you to the day program? If they come back, what's going to, do you need somebody there? And what other services do you have? So you're going to put in what you need from DDS, but also you need to explore other services you can get through Mass Health, such as PCA and so forth. So it's sort of kind of putting together this global plan to show DDS this is where our needs lie. And then based on that, you can have a good discussion regarding the budget. So part of that is, and this is part of the real life legislation. And then part of it is that the value of the budget should be equivalent to what the department would have spent had they been providing the services. Now, it's important to remember that self-directed services was never meant to be residential services, and it doesn't take the place of it. So it is not 24/7 care. And so there are times where somebody's request for enrollment in the self-directed program is going to be denied because the person would simply be unsafe. Because you have to account for, say, a caregiver, is not available. There needs to be a backup because it's never meant to be a 24/7 type of care. And there are other, there's other termination under 115 CMR 14.102. So it basically deals with, is the self-directed program safe? And are you following the regulations in terms of the budget, the administration and so forth? And that would that would be whether it would be terminated or not. And again, if you were to appeal the budget, again, it's always a 30-day appeal from receipt of the budget. And then we would go into the informal conference, which is when it's a mediation process with DDS, in which we would try to present, our budget and our real reasons why we think it needs to be this way. And some things like I've had for the budget, I've had clients that, maybe they're on Nantucket, and they're for them to get caregivers. We're talking about the ferry, we're talking about increased expenses and so forth. So there's a lot of flexibility in that, but you just have to be prepared, know your numbers, and be able to really speak to what services you need and the other things that are driving up costs. Okay, so another specific thing about is transfers. So 115 CMR 6.63 deals with transfers. Now, transfers are they're special requirements. So once DDS proposes that the transfer occurs, that a person leaves one group home and goes to another, first of all, the transfer has to be in the person's best interest. So there's got to be a reason why it's in the letter that DDS sends you has to set forth why they think this transfer is in the best interest of the person and why it's better. The second thing about it is that once you appeal, the person remains in place until the appeal process until there's a hearing on the merits. And there's also, within this, it's the DDS has to submit and, basically, let me see the next slide, I believe, sets forth. No, actually it doesn't. They have to give you a 45-day notice. Once you appeal, the person stays in place. And then it goes to a special administrative hearing through the BSEA. It does not go through the regular, so typical DDS appeals is heard by a hearing officer who's within the Department of Developmental Services. Once you have a transfer, it then gets removed to an independent hearing officer, and so you get really a different, it's more of an independent hearing because you're really losing your home. And the only thing that I'm commenting on this, and I had it happen, not a lot, but I have had happen, and I've tried to argue that I've had agencies who have submitted, group homes that have submitted 45-day letters and notices of having, to say that they can no longer meet the person's needs. I've often argued with DDS that it should have come through DDS as opposed to the agency, because the client often loses their due process rights. And also it is the department, it is a DDS client. And so then DDS would need to be, part of the process in finding a suitable home that could take care of the person if in true the agency says that I can no longer manage. So it's only happened to me, I would say once or twice, but working through DDS, and I feel like that's improved, and DDS has really been responsive in terms of working with the agency and the family to find a suitable placement when it's no longer, when the group home can no longer take care of the person and their needs exceed their capability. So there's also appeal rights under the adult waivers. So that's the adult support waivers, community living waiver, and the intensive support waiver. So we've provided a link here for all the states that set forth the waiver agreements and the amendments. Each waiver on there has what's called an Appendix F, which describes the state's obligation to provide for your due process rights to an appeal and a fair hearing. And in each waiver, when DDS has taken an action that adversely affects the person's waiver services, either they're denied, reduced, or terminated, they have to give you notice. They have to provide you with appeal rights. So you should get a letter on how to appeal the decision. And the continuation of the services should occur while the appeal is under consideration. So again, it would be the same process, within 30 days, you appeal. We then go to an informal conference, and part of the informal conference is where we're going to provide some evidence to show why we think intensive supports were necessary, and why, and maybe what we would do is to get different assessments, or to work with the day program or the shared living provider or so forth, to be able to support why we think that person belongs, their needs have increased, and that they need those particular waivers. So again, with filing appeal, within 30 days of receiving the written DDS decision, you either write, first for the informal conference, the appeal is to the regional director, and within 30 days, and they're quite strict on that. So you want to make sure that you get that out. It doesn't have to be fancy. It can be an email in which you just say, I've received the written notification, and we really believe, one, we're eligible, for intellectual disability, or that we're not getting enough services, or the ISP is not being followed. Something brief of the nature. Don't make it very restrictive, but keep it broad and to the point, and at least preserve your appeal rights. one of the things is, when family members don't sign the ISP, that's insufficient to appeal. Oftentimes, once, they tell you, you have so many days to file the ISP is deemed, consented to, and, you no longer can appeal it. So that's something to really pay attention for. Not that if it's the end of the road, if you didn't appeal it, you can always ask for a modification at any time. The appeal rights should accompany all the all the ISPs that you receive or the DDS decision. If you received an eligibility determination or you were denied eligibility, there is an eligibility determination form that you should have received. And if not, you should ask for it. A lot of family members have come to me about appealing, and you really don't know what you're appealing if you don't know why you were denied eligibility. And that's usually a letter that's written by the DDS psychologist that really spells out for you why they didn't think that you didn't qualify. And that helps us to get the appropriate experts there. Maybe at the informal conference, you might want the neurologist, or you might want, some other caregivers there that will help you argue your case. So it's very important that you get that. Also, if you're doing the prioritization, always ask for a copy of the ICAP and the CCA. Without those documents, again, you're not going to know whether, what am I arguing for? Why, because with the MASCAP, what you're looking for is there's certain numbers. So if you have a number that's less than 40, you'd be, for the ICAP, you'd be appropriate for residential. But if you're someplace within this, I think it's between 40 and 70 or thereabouts, it's sort of a gray area. And with that gray area, there are extenuating circumstances that you can argue, such as the caregiver is elderly, the caregiver is having mental health issues, there's some issues with the housing, or that the person in need of services, they either have something, hard of hearing, their vision is poor, there's some behavioral issues, they need intensive medical care. There's a number of extenuating circumstances that can take you from the sort of the area where, yeah, you need residential supports, but it's become more critical because there are these extenuating circumstances that really make it more critical and that they need it. And always remember that you can appeal the ISP at any time if it's not being implemented. Or if needs have increased or something's changed. For example, if your child is in a residential program, they've now come home and now home life is very, very different. Well, that's a time to say, hey, my child needs to be assessed again, because they're not what they were when they were in a very structured environment. And now they're back home with me and I'm going to need more services. Okay, so after the steps of filing an appeal, per regulation, the informal conference is supposed to be held within 30 days of filing an appeal. In practice, does that happen? Not a lot. If it's not resolved at the informal conference, then DDS will send you out another letter and say, well, we've considered the additional information you provided, and we discussed thus and such during the informal conference, but we're going to stay with our decision, and you have the right to appeal. And then in that circumstance, you appeal to the DDS commissioner, and you have to do it within 30 days. So really, it's important to make that timeline. The fair hearing per regulation must be scheduled within 60 days of the request. It often isn't. And so, I've had, far longer than that from informal hearing but sometimes that can be at our request as well. Like we might want to get, you might need additional time to get an expert. You can request additional time, or we're having difficulty getting some records that we may want to present at the fair hearing. So there is there's quite a bit of flexibility with that. So at the fair hearing, the proof of the burden is on the appellant, which is the person appealing. And so it's basically the preponderance of the evidence. So to show more likely than not, DDS was wrong. But the DDS is per their regulation. It's not an easy burden to meet, because DDS per the regulation does have the authority to make priority decisions and eligibility decisions based on the budget that they have and so forth. So really, even though it's preponderance of the evidence, it's quite a big burden to show that they were clearly wrong, that this person really needed assistance. And we always go to fair hearings with experts, with people to really, to either have a neurologist or maybe an occupational therapist or somebody to show that the reasons why clinically the CES need is greater than what DDS found. So DDS, as part of DDS, there are hearing officers who hear the case. The decision is rendered in 45 days after the hearing. And again, I have had it take longer, so it's not always hard and fast, but that is the regulation. If you get a decision that you do not like, you may appeal to Superior Court, but it isn't like starting over from square one. The Superior Court standard is really going to look to see if there was really an abuse of discretion with the DDS decision. And that is, a very high standard to meet, and it's very difficult to meet that standard. Okay, so we have a couple of examples, and I will kind of read them, and I can also kind of go into, in my practice, how these things have been handled. So Joseph is 33 years old. He's cognitively impaired and he's autistic. He lives in his own apartment in Section 8 housing. He makes his own decisions and he has advisors who help him as needed. He has an ISP, which he's satisfied with. The ISP calls for in-home supports and community services 40 hours per week. Joseph and his DDS support coordinator have been unable to procure the services. Joseph believes DDS has not fulfilled its role in implementing the ISP, so he appeals. At the informal conference, the area director, Joseph is accompanied by his advisor. Joseph and DDS, just a second. Okay, Joseph and DDS discuss the history of Joseph's communication with DDS regarding the implementation of the ISP. Joseph and DDS agree to a communication process designed to assure that Joseph documents his concerns and needs and that DDS timely responds to those needs. Joseph is satisfied that he and DDS can now track DDS's efforts to implement the ISP. And Joseph also believes that the informal conference helped him to have a better relationship with DDS in the future. So in my practice, this is, family members sometimes come to us and they say, yeah, I don't have a day program. I don't, we've really been stuck. Usually I partner with an advocate or a support broker. Sometimes we start with the support broker instead of getting a lawyer involved, because you do want your relationship with DDS not to be confrontational. You do want to partner with them. So I would always suggest, kind of going through the less, without bringing an attorney in right off the bat. And usually what the advocates do is they set up meetings with the service coordinator, and if it's been going on, maybe the supervisor and the area director, and to kind of discuss, let's talk about what services the family thinks are good, kind of to brainstorm. And also in the meantime, say you don't have a day program, say the person has a behavior issue, and really been denied for day program, day program, day program. So maybe what we need to do is start right off with a behavior modification plan. So maybe we're going to get the behaviorists coming in to work with staff and to update the behavior plan to then be able to show to a day program that, yes, this behavior is controllable, the person's in a better place. And then what we do is to have, also to decide with what agencies are we going to make the referrals, who's going to follow up, and to also always put a date of when are we going to, reconvene. Sometimes, you go to a meeting and people say have great ideas, and unless we have follow-up and really accountability on who's going to do what and when are we going to review it, we don't really get anywhere. So, because it's easy to push something to the back burner and so forth. So it's really important to have those meetings, to have follow through, to discuss what some of the issues are in getting in the way to getting the program. And say it is a day program, you don't have a day program. But maybe there's somebody, there's a staff person in the group home who's there during the day, and maybe they can take them out individually to provide some meaningful activity while the remaining residents are in day program. So there's always ways to look at short-term goals, long-term goals, to work with DDS and the group home to try to see if you can't expand. And another thing that we've also have done is that maybe what you do is if somebody's in a group home and you can't get that day program, well, maybe DDS will give you some self-directed budget where you can then hire someone to come in a couple of days and maybe bring your family member out to the community to do something meaningful. So there's always some things, if we look creatively, there may be a way to kind of bridge the gap, figure out how we can solve some problems so that we can eventually get this person the services they need. The second example is Karen is autistic with substantial behavioral issues. Karen is not eligible for an adult waiver since she does not meet the intellectual ability standard. Karen participates in self-determination, self-direction services. DDS issues an individual funding allocation for Karen, which DDS states is equivalent to the cost of traditional services. The funding allocation is $40,000 and is primarily based on the cost of a community-based day support program, CBDS. Karen and her family believe the cost of an appropriate CBDS program for Karen would be higher than the rate DDS has assigned, and further that transportation costs to and from a CBDS program should be included. If these adjustments were made, Karen and her family believe the budget would be $55,000. Karen appeals, an informal conference is held, but is not successful. A hearing is held. The officer finds that transportation costs should be included, but finds that Karen and her family have not established a higher CBDS rate than is indicated. The hearing officer sets the budget at $48,000. The commissioner confirms the hearing officer's decision, and Karen does not appeal to Superior Court. The budget is set at $48,000, subject to funding availability. So in my experience, I've had people who have gone actually for the shared living program, and we've had issues with the budget. And again, what it comes down to, what is the assessment of need? So even with your self-determination, maybe we need to factor in, are there behavioral considerations in which we might need more costs? Do you need somebody who has some behavioral expertise to give training? Do you need an LICSW involved? And so it really comes back to, rather than attacking the budget, you attack the assessed need. And then going back, and there are places where, there's certainly things online which shows how much these services are. And so you take an assessment and assess need, and then you go and base it on, the cost for these extra things that you need, in terms of what, for example, Karen, if she has behavioral issues, there certainly could be additional behavioral supports that would be needed. And that might be an argument that you can bring to DDS in order to increase the budget. But it basically, you might go back to the day program people to find out, hey, what's going on? Do they need to have somebody there one-to-one? Is she causing such a stir that, they really can't manage her behavior, and maybe they need additional services? So again, we always try to go back. First of all, we need an assessment. We need somebody to come forward and say, these are what the needs, this is what we need for her to be successful in this program. And then going back to DDS and looking at their regulations and what their rates of service are to add to that budget. And, some of the difficult part in the real lives, the real lives matter is like, DDS is supposed to be providing under self-direction that which they would provide if they were providing the service. It's hard to know what that budget is because there's a lot of add-ons and it's a lot of subjective, there's a lot of different assessments. So that's where the argument sort of kind of goes. And it really, it's based on the appellant to really show where that, where that discrepancy is. And DDS may not even be aware of it because it just really, no one's done an assessment, nobody's brought it to light. And so that's where sometimes through negotiation, we may be able to increase a budget. So example 3, Mark is currently receiving services through the adult community living waiver. Mark's parents believe that Mark should be receiving services through the adult intensive support waiver. DDS has declined to assign Mark to the intensive support waiver because the MASCAP and other assessment documents do not support the need for the intensive support waiver. Mark's parents believe that Mark's needs have increased since the full MASCAP was done 15 years ago. Mark's parents appealed the DDS decision to decline Mark's entrance to the intensive support waiver. An informal conference is held. Mark's parents present their evidence. Mark's score in the inventory for client and agency planning, ICAP, done many years ago, was very close to the score which would qualify him for intensive supports. Mark's parents argue that since then, his need for supports has increased. Furthermore, Mark's parents note that the very recent updated Consumer and Caregiver Assessment, CCA, shows that support services available from the parents have declined due to the aging of the parents. The DDS area director considers all the records and decides to enter Mark in the intensive support waiver. So a MASCAP done 15 years ago, it clearly is a long time ago. You absolutely, and Mark and his family would be right in asking DDS to do it again. And you can point to some things where he has declined and he has increased needs. And based on that, you can support, with the parents have, as I said, if you look at extenuating factors, you have aging parents, you have parents who may now have major health conditions. The siblings have all moved away and there's no longer any other supports in the family the parents can rely on. All of those things are what are helpful in telling and supporting your contention that, Mark really needs the intensive support waiver. So that's exactly what I would have done in terms of handling this type of situation. So I guess, we have the top 10 tips in appeals. Okay, so if you have identified an issue that you believe is not being resolved correctly, I would always, keep a written, documentation of your contact with DDS. If you make a phone call, follow it up with email. Say, pursuant to our telephone call on such and such a day, we discussed this and such, and we decided that you will make referrals to here, or we will do this, or we will do that. You want a written record, because that's going to help you with your appeal, and with the timeline, because it all blurs after a while. You think you're going to remember it, but I would print off each email, keep a file, keep everything together, any kind of written letters. You just want to be very, very organized in your communication with DDS. And again, like I had said, always when you do communication, we want to write down responsibilities and when people are going to get back to you. So that's really important to establish those dates, put them in your calendar, do a follow-up email on the day. That way it doesn't, after a while we were like, who made the last call? Who was supposed to do what? We all get confused, even the DDS people who have lots of clients and they don't know, they're trying to put out a lot of fires. Even for them, if you follow up in a timely basis, that helps them to stay on track as well. If the service coordinator is not resolving the matter, I would definitely involve the supervisor, the area director, the regional director, the commissioner, depending on what, the situation is. And then sometimes we've also, I've had clients, they've involved the governor's office, their legislators, all in support. And it also depends on what we're trying to resolve. Small things, you're not really going to, go very high, but there might be big issues in which there either was, a dire need for services, or there was some type of abuse, and we might at that point, involve different people and even legislators if we think it's appropriate. And if you believe the DDS hasn't made the proper decision or the proper action, always, appeal, but also make sure that you get that eligibility determination letter, or you have them put it in writing. Why didn't I get this particular service, or why wasn't I eligible for this intensive waiver? And also, I want a copy of my ICAP and my CCA, so you can see what scores you got. And there's also, what's really important, and maybe what I can do is make a link to where the MASCAP, the guide of the MASCAP is, so you really understand the assessment process, and so that you understand that it really should be a collaborative process, not a yes, no answer, but something where you can discuss with the person doing these assessments, the type of behavior, so that they can really understand what the struggle is. And it should really be something where the evaluator is trying to understand so that they can make a correct assessment. And also the biggest thing is just timeline your appeals. That's why I say be organized. Letter denial, put in the calendar, 30 days. Give yourself like 2 weeks before it's due. Reminder, need appeal letter, and so make sure that you stay very organized. So, and if you in an appeal timeline, it's not like all is lost. Certainly, you go through and you can deal with, you can always ask for a modification of the ISP if you think that the needs have increased. If you feel the ISP isn't adequately meeting, your family members' needs, you can appeal again. So there's always a way forward. Don't feel discouraged, and don't feel like that you've lost everything. So during the appeals process, all DDS will have people testify. Sometimes it's the psychiatrist, sometimes it's the service coordinator, sometimes it's the person who did the ICAP and the CCA. But all of their experts are automatically deemed, all their witnesses are automatically deemed experts. When you're the appellant, we need to get experts. So we need to get somebody's CV. We need to show that they are experts in the area of which they're testifying. And I always encourage that you do need to have, depending on what the issue is, you do need to have experts if we're trying to establish an intellectual disability, or maybe a priority situation. Sometimes it's very helpful to have people who are very aware of the caregiving. You might have somebody, an occupational therapist, a physical therapist, a speech therapist. There's all different kinds of experts that may help you with your case. And I think it legitimizes your case when you do have experts who can speak to some of the issues. When you consider appealing, definitely, I think at the beginning stages, as I mentioned, we often use advocates to help get services and things in place. When you start coming to these appeals, it's probably time to hire a lawyer. And then, because you're now looking at, if you need to get experts, we need to have time to find the experts. We need time to have the experts do any formal assessments that we need, and also to have them to be prepared before the fair hearing. So, you want to keep that in mind, considering, the timeline of the fair hearing. An advocate is a wonderful way to start when you're, trying to get, the services you want, and still, not go into this adversarial situation. A good advocate will help you partner with DDS. It's important to stay positive, and to have, good communication at all times with DDS. And we've also used, I've partnered with the Disability Law Center, and the ARC has also been very helpful too, in terms of, sometimes, even though the Disability Law Center doesn't really, might not deal with your situation specifically, but they've been quite helpful in terms of, coming into like a group home and maybe looking at, are some of the restraints appropriate? Are incident reports being done timely? So they've been very helpful in working with our law firm in terms of looking at what's going on in a group home. While we may be dealing with somebody's specific matter, they've often partnered and done some other work within group homes that is very beneficial. And again, like the biggest thing to do with DDS, and it's very hard. And I know when you're a family member and you feel like you feel like you're not really being heard, or there seems to be an adversarial relationship between either you and the group home or with DDS, it's really hard. It's really hard to, be able to be impartial and not be emotional. And that's why I say an advocate is a wonderful resource. They're able to kind of speak at a different level without becoming upset or maybe adversarial or antagonistic. And it's good to always remember to try to be businesslike, to try to form a team, to try to be able to remember the larger goal is, what we really want is a good relationship with the care providers, and so that we can work to develop some trust. And oftentimes the relationship does break down, but to get professionals involved when that happens, when you feel like you're at the end of your rope and you just can't communicate well, it's important. Reach out to an advocate, reach out to an attorney, and see if you can't turn that relationship around. Okay, so I think we have some time for some questions?
Thank you so much, Anne. That was a wonderful presentation, and we do have quite a bit of questions. I'm going to go through them quickly so we can try to cover every one. And I've tried to group them too in certain areas. So the first, and I'm going in order as they came in. The first one is about the percentage of appeals that are successful. Is there any